comply with the provision of recovery of premises law, which is similar to tenancy law. What this means is that the landlord should serve the tenants the proper notice to quit. Now, we'll have to look at risk for realtors. As a realtor, there are so many risks out there. What are the risks involved in real estate? What are the risks for realtors? One is, if you as a realtor, if you involve in dubious selling of properties, one is that you lose your reputation. And you know, once you are dented with a bad dealing in property, maybe fraud, as it may be, your reputation is gone. As I am, if I'm a realtor and I'm selling properties, and maybe you called me, say you want to buy a land, then someone tell you, this guy, he's known for fraud, though. Will you come to me again? No, you will run for your life. So the risk involved is that your reputation will be damaged. Another one is civil liability. You might be sued to court, you pay for damages. Or they might tell you, okay, your civil liability is that you will come out every morning in ESBS and sweep the road, the whole ESBS. Now, another one is criminal liability. You might be in prison, you might go to jail. Now, we'll have to look at the topic, aiding and abetting in real estate. Aiding and abetting in real estate. Aiding and abetting in real estate. What is aiding? We all know what is aiding. You are helping someone. You are helping someone. Aiding and abetting simply means helping someone to do something. Now, when it comes to real estate as subject matter to realtors, what does aiding and abetting means? As realtors, your primary responsibility is helping investors to get a property which they can invest in. Now, the risk involved here is that as a realtor, if you help an investor to invest in a property which you know is fraudulent, you will go in for it. As a realtor, if you involve in fraudulent selling of properties, maybe a property which you know that Arible is not the owner of that property, you now help Arible to sell that property. The hands of justice and law will catch up with you. You will go in for it. So, in simple terms, realtors can be guilty of aiding and abetting if they knowingly assist, encourage, or facilitate fraudulent or unlawful real estate transactions. Even if they didn't collect the money directly, the law sees them as part of the crime. This is very, very important. I appreciate the fact that you registered for this program. It's very, very important, because if you go out there, there are a lot of agents, a lot of realtors posing to be realtors, but they do not know the rudiments of these things. So it is very good that you know these things. You know, selling properties as a realtor, selling properties for developers can be risky. It can be risky because, one, you don't know the foundation of that property. You don't know where this property is coming from. You don't know if this developer is the rightful owner of this property. You don't know if the developer fully paid for that property. So it is one of the reasons why we have cases in the court. After my call to Uba, I think 2 weeks after my call to Uba, we went to, because as lawyers, you are entitled to do free litigation. You are entitled to do free cases. We call it pro bono services. You can go to the prison. So many people are languishing in prison without charging them to court. You can say, okay, I want to help you out. What is your problem? So after our call to Uba, we went to the prison in Abuja. And when we were interacting with them, there are a whole lot of people who are in that prison because of real estate. Realtors and agents. The guy we met, his story was that he helped someone secure a property from a real estate company. 2 years later, when the person wants to start developing that land, the person went into the land, want to start developing the land. The policemen came and arrested them. They found out that that property belongs to someone else. Now, the guy now said, okay, I know the person that sold this land to me. He now went and held the realtor. This is a property worth 100 and something million. He held the realtor. The realtor now went in search of the real estate company. Lo and behold, they couldn't find the real estate company. So there's nothing the investor can do rather than holding the agent that sold the land to him. So the guy has been in prison for over 2 years, and his matter has not gone to court. So these are the reasons why you need to know the rudiments involved and the risk involved in selling properties. So many agents in Enugu that I know are selling properties today that they do not know the history. They do not know the whereabouts of this property. And this is why, if you are dealing with any real estate company, you should make sure that this real estate company have a track record. Any company that is not up to 10 years and above, please be careful with how you deal with them. Some of these real estate companies come, open up an office space. Within a short period of time, you will not see them again. So that is that about aiding and abetting. Then, example of real estate practices: double sales, multiple buyers. When you sell to multiple buyers, this is one of the examples. By helping with sale, the realtors is aiding and abetting fraud. 2, selling land under dispute or government acquisition. Last year, a friend of mine bought a property. If we are conversant with Enugu, you know fire service. After fire service, there's a railway track there. And within the whole of that area belongs to the railway. A friend of mine came back from Canada, so a realtor told him that there's a land there. He went and purchased that land. So when he wanted to fence that place, it was army that came that day, arrested the laborers, arrested the guy himself. To the glory of God, the guy, his father is his father is well-to-do, like he has contacts. So when we started this was a story he told me, I wasn't there. So when he started investigating about that transaction, they now brought up the map, and it was found out that that particular land belongs to the railway, and railway belongs to the government. So it's a government-acquired property, so you do not have any business to go there. So that is that for that. Another one is selling land under dispute or government acquisition. If a realtor knows the land is under litigation or government acquisition and still encourages a buyer to purchase that property, they are aiding fraud. Another one is forged documents. Forged documents, where you abet a document to be forged. Like I told you, people who are not lawyers preparing documents. Okay, thank you. Thank you. Thank you for the slide. So people who are not lawyers preparing documents. Cyber cafes preparing documents, or forging a document of a land, you know. When we talk about C of O, that is a certificate of occupancy, so many people forge it, you know, and when you are being caught, you go in for that. Then, Omonile, land grabbers. That language, Omonile, is majorly used in Lagos and Abuja. So Omonile simply means land grabbers. So realtors who collaborate with land grabbers to extort buyers by demanding illegal fees or reselling land already allocated, they will go in for that. And that one is false representation. marketing a property as free from encumbrance when you know there are issues, unpaid rent, mortgage, or a loan. So when you as a realtor market a product which is encumbered, when we talk about the encumbrance simply means that there's an activity or somebody is actually dealing with that particular land already. So when you sell such property, you are aiding fraud. So let's go down. Legal consequences for realtors. We'll have criminal liability. We'll talk about this. Criminal liability, you might be jailed. Civil liability, you must be asked to pay damages. So how realtors can avoid litigation? Due diligence. As a realtor, if you are selling a property, you should make sure that you actually verify about that property. You should make sure that that property is safe to deal with. You should make sure that that property has a good title, that the person selling this property is the actual owner of this property. Due diligence is actually a big topic on its own. When we talk about due diligence, there is a whole lot of things about due diligence. I'll talk from the legal aspect of it. Due diligence is not only coming to ask, maybe you want to buy this place, you go to the other neighbor and ask him, please, Mr. Rins, the head of Arible, is he the owner of this place? It doesn't end there. There are a whole lot of things that comes with due diligence. Now, when we talk about due diligence deals with going to court to find out if this land is a case in court. Because one of the practices of fraudsters or land grabbers is, if I have a land, maybe I'm in contention for a land with my brother here, and that land is in court, and I'm seeing how the case is going, and this guy might win me in court. What I will do is, I'll come out and look for somebody that will buy that property. And I will sell to that person. I think last month, there was a due diligence I carried out. When I went to court, I found out that that particular land was a case in court. So a party of that case wants to sell that property. A land that you know that is a case in court already, they want to sell the property. So this is one thing every realtor or real estate agent should carry out: due diligence. Verify the documents at land registry, check family consent when buying family land, engage lawyers and surveyors. Like we rightly said previously, you can check family consent, asking the family or the family heads, are you aware that so person wants to sell this family land? All right, next slide, please. Documentation. Always use written agreements, agency agreements, MOU, memorandum of understanding, deed of assignment, and all of that. Professional ethics. Don't collect commission twice. As a realtor, please do not collect commission twice. Let's take, for instance, you collected a commission for a land that is not safe to sell. You collected, let's say, you collected 5 million as a commission. You collected 5 million from this person. You collected 5 million from this person. That is 10 million. What if that land now is a problem? You know, money they sweet to chop. Once we commission coming, they sweet to chop. And when problem they come now, when that's you don't chop the money finish. When you might have finished eating the money, maybe in 2 years' time, then I'll tell you that this land you sold is fake. How do you find 10 million to pay back? You understand? So it's actually one of those things you should not do as a realtor. Don't oversell what doesn't exist. If you are not sure about this property, please do not sell it. Then alternative dispute resolution, ADR. ADR is one of the mechanisms that is used in settling disputes. As a lawyer, every client that comes to me, after explaining things to me, I will always advise you, can we settle this thing out of court? Can we settle this thing alternatively by negotiation, by mediation? Can we settle it without going to court? It is when that matter now is difficult to settle that we can now go to court. So as a realtor, always advise your clients, before you go to court, such matters can be settled outside the courts by negotiation. There's nothing negotiation cannot do. By negotiation, by mediation and all of that. So encourage clients to settle via mediation or arbitration before going to court. Realtors who can settle dispute without court becomes more valuable. Your clients will trust you the more. Your clients will see you as an important person in his life if you can actually settle problems outside the courts. Because when you go to court, it's not just time wasting, it's money demanding. You understand? They will adjourn your matter. You come today, they will tell you this matter has been adjourned to December 2025. When you wait to December, they will tell you this matter has been adjourned to July 2026. This is how it's going to be going, till after 2-3 years, sometimes 5 years. So that is why alternative dispute resolution is very, very important. Now we'll go to landlord-tenant disputes in real estate litigation. I know you are going to love this, because is there anybody who is not a tenant here? If you're a landlord, let me see your hand. Okay, you're a landlord. So the rest of us, we are tenants. All right, the landlord-tenant relationship is one of the most common source of litigation in real estate because it is built on contracts. It is also built on statutory provisions and human behavior. Issues really arise when party fails to uphold their obligations and under tenancy and lease arrangements. Now, 1, rent arrears and recovery. Rent arrears and recovery. The problem that comes up is tenants defaulting or on rent payments or refusing to pay entirely. When you default, you as a landlord, as a tenant, default to pay your rent. Maybe your rent expired December 2025, and you have refused to pay your rent till September 2025, and you think your landlord has forgotten it. No, he has every legal right to recover those rents in arrears. So this is one of it: rent arrears and recovery. Problem: tenant defaulting on rent payments or refusing to pay entirely. Litigation angle: landlords may sue for arrears and possession of that property, of the property, and even the rent. I'm sorry I didn't put it here. Then key law: recovery of premises laws in Nigeria. We have that of Lagos, we have other states. Then come down: illegal or forceful eviction. The problem that arises is some landlords eject tenants without, please go up a little bit. Yeah. Some landlords eject tenants without following the due process. We've talked about this. Apart from the changing of locks, removing roofs or harassment, landlord will want to go through the back door by chasing their tenants without the proper notice, due notice to quit. Then again is rent increase dispute. Landlord increasing rent without adequate notice or reasonable increment. This is one of the issues we have now in Nigeria, because majorly every house in let me say Enugu State, every house in Enugu has increased their rent. Tenants are shouting, why is the landlord increasing the rent when there's no improvement? He didn't paint the house, he didn't change the roof is still leaking, and he's increasing his rent. Legally, the landlord has every legal right to increase his rent. He's not at fault to increase his rent. Increase in rent might come on some conditions, maybe because of the inflation, because of the high rate of building materials, because of the high rates of price of goods. The landlord is also into business, so when your rent cannot afford him a monthly meal for his or him and his family, my guy will increase the rent now. You understand? He's into business. So, but one of the issues that come in here is that landlords tend to increase these rents without proper notice to tenants. Now, there's actually no law that states the period of increase or the period of notice landlord should give to tenants. But then, it is mandatory on the landlord to give reasonable notice. It is when you go to court you now understand what it means by reasonable. So reasonable notice might be 6 months ahead of his expiry of his tenancy. Might be 4 months, it might be 5 months. But legally, there's no proven period when a landlord should give notice of increase. But there is proven period when a landlord should give notice to quit. So notice to quit generally, if you are a 6 month, if you are a yearly tenant, landlord is mandated by law to give you 6 months notice to quit. If you are a monthly tenant, he should give you a monthly notice to quit. If you are a tenancy at will, he should give you 7 days notice. We will come to that, to know those terms. We'll come to that. So increase in disputes, problem, landlord increasing rent without adequate notice. We talked about that. Breach of tenancy or lease agreement. You as a tenant, when you rent an apartment and the conditions of that apartment is for residential purpose, and in the tenancy agreement is stated that you will not cause any noise or smoke weed or bring a lot of people into the apartment, and you as a tenant, you now start hosting parties every now and then, disturbing the neighborhood, smoking India hemp, bringing whole lots of people, you are now breaching the tenancy or lease agreement, as the case may be. So example of tenant subletting without consent. Yeah, this one is more gotten where students live. When I was a student, my friend did it. He subletted his apartment to me. you know. So when your rent is expiring, instead of leaving, you will find somebody and put into that place so that the person will give you small change without the notice of the landlord. So it's one of the breach in tenancy agreement. Then landlord failing to provide agreed services, water, repairs, maintenance. Tenants using property for unlawful or non-permitted purpose. That's where if you rented an apartment for residential purpose and you now convert it to shop, it's now going against the tenancy agreement. Then litigation angle. Either party may bring an action for enforcement of or termination of the tenancy. Recovery, possession. Legal requirement. Landlord can recover possession without serving statutory notice. Legal requirement. Landlord cannot recover possession without serving statutory notices. Notice to quit plus 7 days owner's intention. Now, when we talk about notice to quit, there are so many ways in which the landlord gives notice to quit. Now, if you're a yearly tenant, there are procedures. If you refuse to pay your rent or the landlord wants to make use of that apartment, he will have to give you 6 months notice to quit. I've explained how that 6 months is given. After that 6 months, the landlord will now give you 7 days owner's intention to recover premises. After the landlord gives you 6 months notice to quit, and after that 6 months, maybe you did not pay your rent or you did not leave the property, he will now give you what is called 7 days owner's intention to recover the premises. What this means is that he's now giving you additional 7 days to pack out that he wants to recover his premises. So if you refuse to pack out within that 7 days, he will now sue you to court. Now, one of the misconceptions we have as tenants is that when you are being sued to court, you now say, okay, since he's taking me to court, let me be living freely in his apartment, he will settle it. But it's not like that. Once the matter is in court, you will still be paying for that property. I don't know if you are getting me. If the matter is in court, you are not living free, or you didn't build the house for him. will actually recover if they maybe this is September, he took the matter to court in September, and the matter has been in court from September, October, November, December. To you, with the conceptions we have that once the matter is in court, me as a tenant, I'm living free of charge. No! The landlord will recover those rents you didn't pay for. I don't know if you are getting me. How many of us had that misconception? So it's not, you didn't build a house for him. So where are we? Recovery of possession, legal requirements, yeah. Landlord can recover possession without cannot recover possession without serving statutory notice. Then litigation angle. Failure to comply with the notice procedure renders the eviction illegal, and courts usually dismiss the landlord's claim. So where the landlord failed to give you enough time to pack out or give you enough notice to quit, the court can actually invalidate the action of the landlord. Now, tenancy at will and yearly tenants, issues, real life example, and technicalities. I love this part, and I know you also love it, because this is one of the problems we have today in the real estate sector, most especially when it comes to do with landlord and tenants. Now, firstly, what is tenancy at will? Like I said when we started, there are so many types of tenancy. There's a yearly tenant, there's a monthly tenancy, there's a weekly tenancy. There's also what is called tenancy at will. Now, yearly tenancy is where you pay rent for a year. If you pay rent in January, it will expire in December or January the next year. Now, monthly tenancy is when you pay rent monthly. Majorly, we don't have, I think it's rare to see monthly tenancy in Nigeria. What we have that is outside the country. You pay rent monthly. You say what? Okay, that's good. Then we'll have weekly tenancy. You can be paying weekly. Then tenancy at will. What do you mean by tenancy at will? Tenancy at will simply means where you have an arrangement with the landlord to give you that, to stay in that property for as long as you can talk about or discuss with the landlord. You might be paying rent or might not be paying rent. But the implication of tenancy as will is that the landlord has every right to terminate that tenancy at his will, at the time he deems fit. This is mostly seen where brother and brother relationship. Maybe, what's your name again? Chukunonso. I come to Chukunonso, tell him, now my brother, I'm having housing problem. Can you please let me into your house? Chukunonso will say, okay, you can stay in my house for, like, let's say 6 months. So to enable me get my own apartment. So I'm staying in his house at will. We didn't sign any documents. I might be paying him, I might not be paying him. But Chukunonso deserves the right to wake up tomorrow and tell me, my brother, leave my house. But then what the law actually demands from Chukunonso is that he should give me 7 days notice to quit. So if Chukunonso fails to give me 7 days notice to quit, then he's not doing it the right way. Okay, then rent area. Okay, the landlord-tenant. What is tenancy at will? The landlord-tenant relationship is one of the most common source of litigation in real estate because it is built on contracts, statutory provisions, and human behavior. Issues usually arise when the party fails to uphold the obligation under the tenancy or lease arrangement. 1, rent arrears and recovery. I think we've talked about this. Please come down. Um, go up a little bit, please. Go up a little bit. Yeah, it's okay. Rent arrears and recovery. Tenants defaulting on rent payments or refusing to pay entirely. Litigation angle. Landlords may sue for arrears and possession of property. Key law, recovery of premises law in Nigeria. Come down. Illegal or forceful eviction. We've touched on this. Some landlords eject tenants without following due process. Example, changing locks, removing rules and all of that. I think we've actually discussed this now. Come down, come down. Rents increase disputes. We've talked this. Breach of tenants, we talked about this. Come down. Tenancy at will. Come down, come down. We've passed this place. We've passed all this place. Go up a little bit. Go up a little bit. Go up a little bit. I think there's a misconception. There's a mistake in this slide. We are in tenancy at will. Please go up a bit. We are in tenancy at will. Yeah. Okay, come down. Come down. Okay, I will just use my system. There's a mistake in that. So when we talk about the tenancy at will, we want to look at the technicalities that landlords use these days. I don't want to. There's a landlord here, but if I tell you this, please stop. You don't use it on your tenants, please. Please. Now, we now know that tenancy at will, that the landlord can actually serve you a tenant, you as a tenant, can actually serve you quit notice at any time at his will. Now, what landlords do these days is that when you pay for an apartment, they refuse to give you tenancy agreements and they refuse to give you payment receipts. They do this at will. They know what they are doing. The implication of not giving you tenancy agreements and receipts is that in that tenancy agreement, it is stated the kind of tenant that you are. It is stated if you are a yearly tenant, if you are a monthly tenant, or a weekly tenant, or tenants at will, as the case may be. Now, what landlords do these days is that they will refuse to give you tenancy agreement. You go to them, landlord, give me tenancy. Tell you, don't worry, leave. Receipts in court, don't worry. As time goes on, we'll forget about it. Because that receipt also will state the kind of tenancy that Chukunonso paid so 1 million for as a yearly tenant for an apartment of 2-bedroom flat in Independence Layout on so date signed by landlord tenants. So the tenancy agreement and the payment receipt serves as evidence of the kind of tenant that you are. So landlord now refuse to give tenancy agreement. Do you know why? The reason is that when they now start having issues with you, the tenants, you will not have any evidence to show that you are a yearly tenant. And they will not give you notice to quit at will and tell the court that you are tenants at will. I don't know if you understand. So a tenant at will can be pursued or chased out of the property at any time. Do you get the technicality now? And some lawyers, sometimes when it comes to court, they say lawyers are dubious. They collect money and say what is not the truth. Law does not look at emotions. What we look at is what is presented. That's why if you are dealing with a lawyer, you should know that the lawyer knows what he's doing. So when it comes, the lawyers will prepare a document. There's a case, I sent Trix that thing, but I don't know. I sent him that thing. There's a case we had, I think, lately last month. These are students staying in an apartment, self-con. Now, that's that house was, the person who is the owner of the house died. So another person took over the house. And you know that when you come newly as a tenant, you have to pay management fee, lawyer fee, and all of that. The landlord also benefits from that thing. So the guy